Help in Pharmaceuticals in association with Higher Secondary Principals Forum.
Hello, students. I'm here to present to you Chapter 5 of Secretarial Practice, Role of Registrar of Companies and Companies Act 2013. I will present this unit in two parts. To begin with, Role of Registrar of Companies. I have three questions. What is Registrar of Companies? It's a body in India under the administrative control of Ministry of Corporate Affairs. The Ministry of Corporate Affairs has regional directors in major states of India. Second question, who is the Registrar of Companies? The Registrar is an official appointed by the central government to register companies in India under Indian Companies Act 2013. And the third question, what is the role of the Registrar of Companies? To foster business ethics and business values among the companies as they follow the provisions of the Companies Act 2013. With this brief information, I move on to a company gets floated, comes into existence through the office of the Registrar of Companies. The official is the registrar who is appointed by the central government for registering the companies in the state under the Indian Companies Act 2013. The ROC issues the company a birth certificate, and we call it the incorporation certificate. The Registrar of Companies also maintains records of registration of companies. The ROC is regulated by the Indian Companies Act 2013 and is under the administrative control of the Ministry of Corporate Affairs. So now, what is the role of the Registrar of Companies? Is explained through the duties of the Registrar of Companies. What do you think will be the first duty of the Registrar of Companies? To register the companies. And once the companies are registered, the registrar has to supervise the companies within the state. Look after the administration of the companies within the state. And these duties I have placed in the form of a table, bringing to picture the main word which will help you explain the duties of the Registrar of Companies. Let's start. Duty number 1, register. To register the companies in the state and issue incorporation certificate. The certificate is also called registration certificate. Second point, administration. To look after the administration of the companies registered in the state. Third, supervise. To supervise and control the companies operating within the state. Maintain. To see that the companies maintain various statutory books, to name a few. Register of members, register of directors, register for sweat equity shares, minutes of the meeting, and name them. Action. Yes, the companies have to be within the provisions of the Companies Act. If not, the registrar will take action on companies that do not comply with the provisions of the Companies Act. And the sixth point, to receive documents, returns, resolutions for filing under the provisions of the Companies Act 2013. With these 6 duties, we would want to know what are the powers of the Registrar of Companies. If the Registrar of Companies is bringing the company into existence, the Registrar has the power. The power for what? To call for information of the company, to call for explanation from the company, to take action on the company. Again, I have set this presentation in the form of a table with the main word which will help us frame the sentences for the powers of the Registrar of Companies. The first power, call for information. The Registrar has the power to call for information on the profit and loss accounts, the balance sheet, and the annual returns of the company. The Registrar has the power to call for explanation when any complaint or allegations are received from the shareholders and creditors of the company. Inspect. The Registrar has the power to inspect various books of the company, books of accounts and other statutory books. Now, if the company doesn't follow the provisions of the Companies Act 2013, the Registrar has the power to take action on these companies. How will the Registrar go about taking action? Is the next power to issue notices to the companies that are in default in following, complying with the provisions of the Companies Act. This will be followed by impose fines on companies that do not comply with the provisions of the Companies Act. With this, 6 powers of the Registrar, we move on to returns. Returns are various documents that have to be filed with the Registrar as registrations during the year. But what we are going to do in this topic are returns to be e-filed through the net, through the computers, and annually, that is when the company has its financial year ended. What are those special returns which have to be filed mandatory by the company? We have the consolidated financial statement, the balance sheet, the profit and loss account, the annual return, the director's report, and the certified true copy, CTC, of the resolution. Each of these documents have to be submitted under specific e-forms. Form AOC number 4 for consolidated financial statement, and the purpose of filing is companies which have subsidiary company, associate company and joint venture. Balance sheet type of e-form to be used is Form AOC number 4, filing of financial statements with the ROC. Profit and loss account, Form AOC 5, filing of profit and loss account with the ROC. Annual return, Form MGT 7, to be filed by companies having share capital as well as companies not having a share capital. Director's report. Director's report along with the following annexure: AOC 2, MGT 9, Secretarial audit report. And the sixth is the resolution. A copy of the resolution has to be filed. So it has to be a certified true copy. And the e-form is Form MGT 14, except for a private limited company. This resolution is passed at the annual general meeting for the adoption of the balance sheet and the director's report. With this, we move on to special resolutions to be filed with the Registrar of Companies. Resolutions, what are they? Companies take various decisions at properly convened and constituted meetings. These resolutions are drafted and they become special when they are passed by 75% of the majority votes. What are those special resolutions which have to be filed with the Registrar of Companies? Number 1, conversion of a private company, private limited company into one-person company. One-person company is a new concept under Companies Act 2013. This company has only one shareholder and one subscriber to the Memorandum of Association. Second, when there's a change of location of the registered office in the same state but outside the local limits of the city, town and village where it is situated. Third, change in the name of the company. Fourth, issue of preference shares. Fifth, issue of sweat equity shares. Sweat equity shares are offered by the company to the directors and the employees of the company for their services to the company. Sixth, reduction of the share capital. Seventh, removal of an auditor before his term of office expires. And the eighth, reappointment of independent director. So we have got to understand the various subtopics that come under role of the Registrar of Companies. With this, I end my first part of the chapter. Role of Registrar of Companies and Companies Act 2013. Presenting to you part 2 of the chapter Companies Act 2013. I will speak on merger and amalgamation, winding up of the company, company liquidator, National Company Law Tribunal, all under Companies Act 2013. Merger. What is merger? Unification of two existing companies into a single new company entity. What's the purpose of a merger? To increase shareholders' value, to gain a market share, to expand into a new segment. Since properties and liabilities are to be transferred to another company, the central government, the official company liquidator, the regional directors of Ministry of Corporate Affairs, National Company Law Tribunal exercise and discharge their powers. The National Company Law Tribunal orders to circulate the following. The draft of proposed terms of scheme of merger or amalgamation, which is adopted by the directors of the merging company. And this is to be circulated among the shareholders and creditors of the company. A copy of this draft scheme of merger and amalgamation has to be filed with the Registrar of Companies. Third, a report adopted by the directors explaining the effect of compromise on each class of shareholders on the scheme of merger and amalgamation. Fourth, the report of the expert with regard to valuation of assets and liabilities. And the fifth, a supplementary accounting statement. So what are the rules regarding merger and amalgamation? Merger is where two or more small companies come together to form to one new company. So there are two companies involved, the transferor company and the transferee company. Let us see the rules regarding merger and amalgamation through this presentation. This scheme of merger or amalgamation may be entered between two or more small companies or between a holding company and a subsidiary company. Second, since there are two companies involved, the transferor company and the transferee company, both these companies have to send notices inviting objections and suggestions to this scheme of merger amalgamation to their shareholders and creditors. Third point, convene an annual general meeting. Why? When these objections and suggestions are received by the company, they have to be discussed at the meeting. And then, after sufficient discussion, they are going to be considered by the companies in their annual general meeting through a resolution that will be passed. Fourth, filing of declaration of solvency. Very important. Declaration of solvency is drafted by the board of directors of the company. This declaration states that the company will be able to pay off its debts out of the assets realized and the proceeds received. So this declaration is to be filed by the transferor company and the transferee company with the Registrar of Companies. Filing of the scheme of merger and amalgamation. The transferee company shall file a copy of the scheme of merger and amalgamation after it is approved by the central government, the Registrar of Companies, and the official liquidator. Next, objections and suggestions of the Registrar and official liquidator to the scheme, if any, must be conveyed to the central government within a period of 30 days. Last, the central government may file an application before the tribunal. And when the tribunal is of the opinion that the scheme of merger and amalgamation is as per the procedures specified, and I have given you them in point form, the tribunal will pass the order for merger and amalgamation of the company. Now, what is winding up of the company? Liquidation, we call it, in other words. In this process, an official liquidator is appointed. For what? To realize the assets of the company, to pay off the debts, the liabilities out of the assets realized, and if any surplus remains, it is to be distributed among the shareholders of the company according to their rights. So what are the modes of winding up of the company? Liquidation of the company, dissolution of the company. They are in two ways. The company can be wound up by the tribunal. The company can be wound up voluntarily. So let us have a reading of winding up of the company by the tribunal. According to section 271 of the Companies Act 2013, a company on a petition under section 272 be wound up by the tribunal on the following grounds. Number 1, if the company is insolvent. What is insolvent? The company is unable to pay its debts. Its liabilities are more than its assets. So the company is declared insolvent. Second, if the company has passed a resolution which is special, that it has to be wound up by the tribunal. Third, if the company has acted against the interest of the sovereignty and the integrity of the country, India. And the last, if the tribunal is of the opinion that the affairs of the company are conducted in a fraudulent way. What is fraudulent way? It's violation of the provisions of the Companies Act 2013. The tribunal can come to this conclusion only on an application received from the Registrar of Companies or any official of the central government. Let's come to the second mode, where the company voluntarily winds up. This I presented to you again in a table with main words which should help us understand the process in this winding up of the company. Number 1, declaration of solvency. This is a declaration which is given by the board of directors, stating that the company will be able to pay its debts out of the assets realized. Second, appointment of company liquidator is done in the general meeting of the company from a panel that is prepared by the central government. Third, the company liquidator will prepare a report. A report of what? The assets that are realized and the liabilities that are paid off to the satisfaction of the creditors of the company. Next point is the meeting of the creditors. A meeting of the creditors will be called for passing a resolution for voluntary winding up of the company. Publishing of the resolution. Publishing of the resolution to wind up voluntarily has to be done within 14 days of passing of such resolution. And the last is the general meeting of the company. This is the meeting of the shareholders of the company. The shareholders of the company have to be satisfied with the report of the company auditors that the assets have been realized, the debts have been paid off to the satisfaction of the creditors, and whatever surplus is to be distributed among the shareholders of the company. When the shareholders are satisfied with the report, they will pass a resolution for voluntary winding up of the company. This resolution is sent to the tribunal. The tribunal will see that the process of winding up of the company is followed as per the provisions of the Act. And if the tribunal is satisfied, the tribunal passes the order for voluntary winding up of the company. That is, dissolving the company. Now, we did mention official liquidator, company liquidator, but I did not explain to you there. Let me explain it now. Official company liquidator is an officer who helps the court in conducting and completing the winding up proceedings of a company. The powers and the duties of the company liquidator under Section 290 of the Companies Act 2030 are to carry on business of the company so far as may be necessary for the benefit of winding up of the company, to sell the movable and immovable property, auctionable claims of the company by a public auction, to sell the whole of the undertaking of the company as a going concern, to raise any money required on the security of the assets of the company, to invite and settle claim of creditors, employees, or any other claimant, and distribute the sale proceeds, to inspect the records and returns of the company on the files of the registrar. Seventh point, to do all acts to execute in the name and on behalf of the winding up of the company all deeds, all receipts and other documents, and for this purpose to use the company's common seal. The next topic under Companies Act 2030 is National Company Law Tribunal. Consists of the President, the members. The members consist of judicial members and technical members. Let's see what qualifications are required for the President of the National Company Law Tribunal and the members of the Tribunal. President. A person is qualified to be appointed as a president if he is or has been the judge of the High Court for 5 years. Judicial member. A person is qualified to be appointed as a judicial member if he is or has been the judge of the High Court or the district judge for at least 5 years or an advocate of a court for last 10 years. Technical member. A person is qualified to be appointed as a technical member if he is a member of Indian Corporate Law Service or Indian Legal Service for last 15 years or has been in practice as a chartered accountant for at least 15 years or has been in practice as a company secretary for at least 15 years or a person has proven his ability, integrity, having special knowledge and experience in industrial finance, industrial management, administration, accountancy, labor matters, or has been a presiding officer of a labor court for at least 5 years. Next topic. Removal of a member of National Company Law Tribunal according to section 417. Who can remove? The central government. After consultation with the Chief Justice of India, the member can be removed from office in the following circumstances. 1. He is adjudged as insolvent. His liabilities are more than assets. 2. He has been convicted of an offense which involves moral turpitude. What is moral turpitude? If the personal character of an individual doesn't match with society values, then this person is less trustworthy. Next, if he has become physically or mentally incapable of acting as a president or as a member of National Company Law Tribunal. Next, if he has acquired such financial or other interest which is likely to affect his functions. And last, if he has abused his position in office. All these circumstances will disqualify a person from holding, being a member or the president of the National Company Law Tribunal. Well, students, this topic 5 was presented to you basically with table presentation and the main points which will help you complete or frame sentences. With this, I come to an end by informing you that there are two very good professions highlighted in this topic. One are regional directors of Ministry of Corporate Affairs, and second is company official liquidator, which you can think of after your standard 12th board exam, when you intend taking up your further qualifications. Thank you.
Prudent Scholars, powered by Lupin Pharmaceuticals.
अब आपकी सुरक्षा आपके हाथों में। ल्यूपी सेफ हैंड सैनिटाइजर, आपका और चेन्नई सुपर किंग्स का फर्स्ट लाइन ऑफ डिफेंस। अब आपकी सुरक्षा आपके हाथों में। ल्यूपी सेफ हैंड सैनिटाइजर, आपका और चेन्नई सुपर किंग्स का फर्स्ट लाइन ऑफ डिफेंस। अब आपकी सुरक्षा आपके हाथों में। ल्यूपी सेफ हैंड सैनिटाइजर, आपका और चेन्नई सुपर किंग्स का फर्स्ट लाइन ऑफ डिफेंस।